then get started. We had a busy committee meeting and hearing yesterday, which we are continuing today on continuing the hearing on Senate Bill 273. With that then, committee, we will go ahead and have our first proponent conferee. That would be Mr. Eric Stafford, Kansas Chamber of Commerce. Mr. Stafford, if you'll introduce yourself and welcome back to committee.
Absolutely. Thank you, Madam Chair and committee members. Good morning. My name is Eric Stafford, Vice President of Government Affairs with the Kansas Chamber, and we appreciate the opportunity to be here in support of Senate Bill 273 today. The House has their version that's up. It's rather different than what you guys have, but overall there's some good things in each and some things that might need to be modified in each. With the pandemic, I think we've learned that there are deficiencies in our Emergency Management Act from both the legislative branch aspect, but also the executive branch aspect that folks would probably like to see some different changes to. With those, Ryan Kriegshauser is an attorney member of ours and has represented quite a few of our members throughout the pandemic, largely dealing with local units of government as they were facing challenges when the shutdown first started occurring on who's essential, who's not essential, how's this going to work, and that's actually what led, as I think I saw Mr. Will Lawrence sit down back there, that we were regularly communicating with the governor's office, and in communications with them, they were not wanting to shut businesses down, wanting to kind of just see how things happen, but then we started to see various patchwork approach as counties were taking very aggressive approaches here, but nothing over here, and it was becoming a very tough and difficult compliance headache for our members that were operating in multiple locations. That's kind of what drove the statewide approach that the governor's office eventually took. But all that said, Ryan has represented a lot of our members throughout that process. I think his testimony, or our testimony, was jointly submitted, has a lot of written recommendations, and I'll save the bulk of the time for him, if you don't mind, Madam Chair, to kind of go through the specifics, if that's okay with everybody.
Sure, that'd be fine. Thank you. And
thank you.
Please introduce yourself and welcome to committee.
Thank you, Madam. Thank you, Madam Chair. My name is Ryan Hauser, as Mr. Stafford said, and I know my time is limited because there's so many people who want to testify, so I want to move through. I think
let me clear that up. Thank you for bringing that up. I'm going to pause for just a moment. Committee, we had talked yesterday that we would have 30 minutes of testimony today. Since that time, we've had a number of conferees sign up to give testimony, so we're not limiting it to 30 minutes today. We will hear the list of conferees that we have. I believe there's 5, so please don't feel time constricted. We do need to keep testimony concise and not repetitive. And we had also talked that committee would work through 1 p.m. today to be respectful of the 1:30 committees that meet and are trying to work bills there too. So we'll work through till 1 o'clock and we'll see where we are. And if we need to reconvene after session today, this afternoon, we will plan to do that. So with that, thank you for allowing me to interrupt, and go ahead.
No, I appreciate that. I had limited my spoken comments to just give time for everyone, so I'll defer some of the time for questions and interactions on what you want to talk about. I'd just like to, I have a dozen or so suggestions in my testimony. I want to highlight 3 of them in my spoken comments. Section 4 of this bill is incredibly important. That's the 72-hour hearing section, and I think that's incredibly beneficial. It's somewhat patterned off of 65-129C, which is in the infectious disease statute. It allows for a person under an isolation or quarantine order to demand a hearing within 72 hours, and then it's the state's burden to show whether or not the quarantine or isolation is reasonably necessary and medically necessary and reasonable. And so I think the Section 4 provisions of this bill incorporate some of that thought. The two suggestions I might add to Section 4 is notice to the individuals under an order. In Section 129C in the infectious disease statutes, it requires that any local health order tell the individuals under the order that they have a right to a hearing. Otherwise, people may not know. And in fact, at the beginning of this pandemic, many of those local orders at the county level that Mr. Stafford spoke about did not include this notice provision, and I interacted with a number of counties on that aspect, that it's important that the people under those orders know their due process rights. And so that's one suggestion in Section 4, is to include the requirement that any order that's applicable needs to notify the people under that order that they have this right. And second, one of the things in 129C that is very important, we found it very important throughout the pandemic. I've done a number of isolation and quarantine hearings, and other lawyers I've worked with have done a number of isolation and quarantine hearings. And there's some aspects of the 129C procedure that are important, one being access to counsel. So in the 129C provisions, it actually allows for counsel to be appointed. And just in my experience, interacting with parents who have children who are subject to sometimes close contact letters and sometimes actually subject to true quarantine orders, they don't know how to proceed. And 129C seems to contemplate that these parents, who are lay people, would just wander into a courtroom, file a petition for an isolation and quarantine hearing. The court would know that this statute exists and give them a hearing within 72 hours, that those parents would somehow know how to serve the county and get through all the procedural stuff before the hearing. When the court says, you know, our docs is pretty full, we can hear you maybe 2 Thursdays from now, and they need to come back and say, no, this is a statutory right. I do a hearing within 72 hours, and almost always when we filed these hearings, you had to notify the court that there is a statutory requirement to hear the case within 72 hours. It's too much to ask of parents without counsel to jump through all of that. And so one suggestion is maybe a prevailing party in one of these Section 4 hearings, a 72-hour hearing, should be able to get attorney's fees. There has to be some access to counsel. Otherwise, just general small businesses, general individuals who don't have, I think on average a 72-hour hearing costs about $5,000 to $14,000, and that's a tall order to get families to finance that with a private attorney. Otherwise, you're expecting public litigation firms like, you know, Kansas Justice Institute, which has been involved in a number of these cases, but they have limited resources, and so you're basically relying on them to bring these types of hearings if they're necessary. Another comment I heard about Section 4 yesterday is access to the courts, and there's a concern that there might not be access to the courts, and I'll tell you that me and all the other attorneys that did these 72-hour hearings, we never were denied access. The Supreme Court rules that closed down the courts allowed for isolation and quarantine hearings. And so even if a court was shut down, if you contacted the court, you filed a petition for an isolation and quarantine hearing, we always got it. I'm not aware of any situation where someone was denied access to a quarantine or isolation hearing due to this pandemic. Now, is that always the case in any possible disaster? I would say most likely through virtual technology, that hearing will be available in some way. And if it's not, we have bigger problems. I mean, we're at a martial law constitutional situation, which is much broader, and it's probably outside the Emergency Management Act. So I would hope that public policy makers would anticipate most likely the court would be available, and they were in this situation. And so I just wanted to let the committee know. I reached out to some of those attorneys this morning just to make sure that they were not ever denied an isolation and quarantine hearing, and that turned out to be the case with my conversations this morning. I just didn't want to speak out of turn for them. The other aspect that I really want to highlight to the committee is this idea of illegal rulemaking. And that's one of the situations I proposed some language for Section 8 in the bill. And what we saw through this pandemic is the governor or a county would issue an order. We saw it mostly through the reopening process, where the governor issued a reopening order. It was ambiguous, it was vague, no one knew what the terms in it meant. And then she foisted it upon local governments to enforce and try and figure out how to apply this. And so we defended a bar in Emporia that was actually prosecuted by the city of Emporia for opening during the reopening phase, where restaurants were allowed to be open, bars were not allowed to be open. So this business reconfigured their business to qualify as a restaurant. They sold more food. They had a food service license already. And so they reconfigured their business to meet the definition of a restaurant as they understood it to be. By the way, restaurant, bar, it wasn't defined in the governor's order at all. And so they opened, and they were prosecuted by the city because a Flint Hills County Health Department employee decided that her definition of a restaurant was you had to have at least 30% of your sales derived from food. Well, that's not written down anywhere. It wasn't in the governor's order. And when that happens in state government, it's rulemaking. And oftentimes the legislature will give authority to an executive branch agency to make a rule. And that there's due process associated with that. There's notice, there's comment, there's a hearing, and then it's actually promulgated in writing so we all know what the rules are. Well, this was happening at the local level oftentimes without any due process. Emporia is an example. You just have an employee decide, well, this is my definition of bar and a restaurant. And you can imagine where this could go. What if you had a local health employee that was just a teetotaler and they decided their definition of a bar is selling any alcohol whatsoever? They just got prohibition in their county. I mean, they get to decide. And so there needs to be some language in there saying that the Kansas Rules and Regs Filing Act applies. And in a long-term disaster where these emergency orders drag on month after month, which is what we saw here, the Adjutant General has regulatory authority to issue regs under KEMA already. They just never did it. And I think that's important. If you tell the Adjutant General's office, listen, if you're in a situation where this goes a long time, you need to provide definitions. When there's a question about what a bar versus a restaurant is, you need to define those things so local governments know how to operate and the citizenry knows how to operate. We had a case in Johnson County where a fitness center reconfigured their entire business. The governor's order said that you could reconfigure your business to meet an essential function, and that's what they did. They focused on selling supplements, more community health and wellness. They focused on essential functions personnel, training and education, and the county came back and said, well, that's not what meets our definition of an essential function. Essentially, training police officers in Pilates, although it may technically be training and education of essential function personnel, what we meant, or what we believe the governor meant, was in service and that type of thing. Well, if it's not written down, if there's no due process, then you have local governments trying to just create these, they're essentially creating law out of thin air without any due process, and I think that's something that this bill should deal with. And then the third aspect, it will come up time and time again, I think, during this session, is Section 48933 and what compensation is due and when is that compensation due. And this bill made some minor changes to that provision of law, and it just basically said intangible damages are not included. And I'm struggling to know exactly what that means. When I think of intangible property, I think of intellectual property. I don't know if businesses would bring a suit for compensation under that, but according to 48933, it's clear that compensation is due for something. It says if your private property is commandeered or otherwise used, then you can go through this process whereby a court appoints appraisers, they look at the business and determine a level of damages, submit a report to the court, and then the parties can either appeal if that amount is too small or too little. And that is a process that exists in law. The question, and we filed a case on behalf of a gym in Wichita saying, look, you shut us down, that's using our business, we are filing a KEMA compensation claim under current law. And the Attorney General said this is a big public policy problem because there's lots of companies in the same situation. Any one of them could bring a current KEMA claim under current Kansas law. And so let's stay that case and let the legislature hammer it out. And we introduced a bill on Tuesday to start that discussion and make a proposal on how we can globally settle this compensation question. But that's retroactively. That's for the businesses that have already been harmed and what is due to them. Prospectively, we all need to know what the rules of the game are. We need to know, governments need to know, hey, if we go and shut these businesses down, if we impose curfews, and many restaurants are still under curfews or limits on their hours of operation currently in Johnson County and Sedgwick County, even though Kansas City apparently got rid of all their restrictions except for social distancing and mask mandates, Johnson County is still under curfews, or basically restaurants can't go past a certain time. And so What does that mean? Counties need to know this is important enough, this provides us enough benefit that we are willing to pay for it. Right now, they don't have any or seemingly immediate cost to shutting down businesses. But to those businesses, it's an immense cost and it's an immense burden. Right now, you know, if a local health officer says, I got to do something, I know only 1%, according to KDHE, only 1% of cases really comes from restaurants and bars, but I need to show I'm doing something to be proactive. Let's put some limitations on operations on restaurants and bars. Without a cost associated with that, it isn't the balancing test that I think public policymakers would want to see. I think the government should look at a situation and say, look, this is going to be a huge impact on the people I'm affecting. It's going to be a cost to me, and given the situation, given the pandemic, it's worth it to pay those businesses to shut down. Otherwise, they can just shut down and cause immense harm without any immediate cost to them. Now, in a few years, when property taxes are due and those businesses no longer exist, the state and the county will have that effect. But I've suggested some language in my testimony to define use, to define property that would be subject to it. And so I know there's a lot more in that testimony. And then I'd also refer the committee to our testimony during the special committee session. I think I gave a number of recommendations and a lot more depth in that testimony, but I'm happy to answer questions, and I know Mr. Stafford is as well, but I want to be respectful to everyone else's time. Thank you.
Thank you, Mr. Biegshauser. Committee, we're going to hear from all the proponents first, and then we will take questions for them at the end and conclusion of their testimony. With that, then, we will invite Heather Morgan from the Kansas Association of Community College Trustees. Please introduce yourself and welcome to committee.
Thank you very much, Madam Chairman. I'm Heather Morgan. I'm the Executive Director of the Kansas Community College Trustees Association. We come before you today not necessarily to weigh in on if this is a good idea or a bad idea, but to highlight the issues of how your current bill would affect Kansas community colleges. Throughout the pandemic, we've worked closely with the governor's office and her staff, and they've been wonderful. But there's been a lot of ambiguity about where do community colleges fall and where does higher education in general fall within different frameworks. Some people like to think that we're businesses. Some people say, well, KBOR, well, we don't fall under KBOR either. Then there's K-12, well, we don't fall under K-12, but we partner very closely with K-12. And so in Section 5 of the bill, as you carve out local school boards, each one of our community college also has a locally elected board of trustees. Just like there's a local school board that has taxing authority, we have a local community college board of trustees with the same taxing authority. In this current disaster, what has happened is oftentimes I would be trying to seek clarity for where do we fall, how do we fall, and then try to communicate that back to 19 institutions across the state, working with probably 80-some counties, because a lot of our colleges also have satellite locations. So one of the things that we contemplate under this bill, just as an example, Pratt Community College operates a satellite center in Attica. So if there's a health emergency in Pratt County and Pratt Community College is closed, our faculty bargain under KNEA, just like K-12 teachers, if the college is closed, can we operate in Attica, at our Attica Center where there's not a health emergency? Those are the reasons and the policy issues that really come into effect when you think about the local control and giving the Board of Trustees the ability to consult with local health officers to make good decisions. They've been elected by the public to make decisions on behalf of the college, and we'd like to make sure that that local control exists. The other thing that happens is in a K-12 school system, about 30 to 40% of our enrollment is dual or concurrent students. So the faculty member may be our faculty member going into the K-12 classroom teaching a dual credit class. If our faculty member can't go in and teach that class, what happens to that credit that's needed for graduation? There are just some policy implications, and we are just inextricably linked with K-12. This current disaster has highlighted some issues. Our enrollments are down about 12%, and almost all of it is in K-12 students that we're not able to take our classes for whatever reason, schedule mismatch, ambiguity, things like that. And so we don't want to cause a problem with what you're trying to do or what anyone's trying to do, but really are just seeking statutory clarity about where do community and technical colleges fall. We're not under the Board of Regents, we're not universities, we're not K-12. We have locally elected boards and just want to be really clear about where we fall in the new statutory framework, and I'm happy to stand for questions at the appropriate time.
Thank you very much. With that then, I will call for, are there any other proponent conferees in the committee meeting room or online? I think I see one there. Senator Steffen, if you'll introduce yourself, and welcome to the committee.
Microphone's on. Yeah, thank you, Madam Chair. Mark Steffen, MD, Senator for the 34th District. Thank you for allowing me to be here. If you would bear with me for just a minute. I got pulled out of another meeting very quickly, and I need to pull up the exact verbiage. What I want to try to help do is define accepted science in this bill. I'm still looking for the exact verbiage. Again, my apologies. I think I can basically walk you through it. You know, the term accepted science is obviously very open and very vague, and has been utilized to the benefit of one viewpoint and to the detriment of another over the past year. What my statement does, and I know a lot of you have that statement, is it tries to put parameters on what's acceptable as far as scientific data. In the medical community, in the PhD community, in the scientific community, there is a pyramid of defining the superiority or the inferiority of scientific data. At the very bottom is anecdotal stories. For instance, a doctor in my area testified that he was sawing sheetrock wearing an N95 mask, and when he took that mask off, there wasn't any sheetrock dust on his face. Therefore, N95 masks work to decrease the incidence of COVID-19 in a society. Well, that's as bad a scientific data as you can come up with. From there, it's kind of observational studies. Well, we look back, we look at some data, we kind of have a preconceived idea how we want it to play out, and so it ends up being skewed, erroneous data. And so my statement says anecdotes won't work, retrospective observational data doesn't work. At the very top of the pyramid is systematically reviewed, controlled, randomized studies. And that's where you can take particular questions like, do masks decrease the incidence of COVID-19 in a society? And that's because that's an incredibly complex study that takes time, it takes effort, it takes lots of statistical work to decide if it's significant or not. And when you look at a multitude of them and analyze a multitude of these studies, when you come down to a conclusion, it's very compelling as to its accuracy. And so, again, in total, this statement will say that the top of the pyramid and a row or two just under it is acceptable to start making orders or even mandates, where the bottom of the pyramid is not acceptable, is not good enough data to start imposing your will on others. So that's basically what it says in a nutshell. It's free of government organizations and their inherent flaws. And it's a nice, clean paragraph that ultimately creates a playing field where if two people don't agree on a method trying to be instituted, they've got rules by which they're now going to have to follow to make the decision of whether that method can be instituted or not. And I think the one lesson we clearly learned over the last year is we didn't have a playground, we didn't have a level playing field, we didn't have any parameters on what was acceptable and what wasn't. So I think ultimately, again, I'm working with the revisers to get that to you guys. But again, in short, it creates a playing field of long-lived scientific terms and scientific studies to decide what warrants imposing one's will upon an individual. Thank you.
Thank you. Are there any other proponent conferees in the committee meeting room or on WebEx? Senator, if you wanted to stay for any questions, we're going to move to questions pretty shortly if you're available. Up to you, sir. Committee then, I don't see any other conferees on the proponents, so we will then note that there are proponent written testimony from Derek Schmidt, Kansas Attorney General, in your committee folder, and also from Mike O'Neill on behalf of the Kansas Policy Institute and on behalf of the Kansas Justice Institute. With that then, committee, we will open it up for questions for our proponent conferees from the committee. Yes, Senator Corson.
Thank you, Madam Chair. I just have one quick question for Ms. Morgan, and apologies if I didn't understand this part as clearly. You made a very good and compelling point about the need for us, through this legislation, to provide clarity. I was just a little bit unclear whether your view is that this, as currently written, does or does not provide the clarity that would be helpful to you, and which I think you've correctly and understandably identified as a need for you to operate. I was just unclear on that. I'm sorry.
Please identify yourself for those online when we come to the podium, please, or when you speak online, please identify yourself for those who aren't in the committee meeting room. Thank you.
Heather Morgan, Executive Director of the Kansas Association of Community College Trustees. As currently written, we are not in the bill, and so we aren't sure where we are at. So I would say that would be unclear.
I have a follow-up question. Is it your position then that when the bill talks about businesses and other civic institutions that doesn't cover the community colleges? I'm just curious if that's a catch-all that catches you guys or it doesn't, in your mind.
In our mind, we would probably never term ourselves as a business as normal people outside of this building would think of a business. And so if we somehow wanted to be codified as a business, perhaps just a statutory reference that it includes community and technical colleges might be a way to say businesses including us, because it's very gray area in terms of the law. Certainly we're references of institution of higher education. Statutorily, we're a community college. It's a stretch to the average person to think that we would be a business.
I think we had Senator Haley next, and then Senator Baumgartner.
Thank you, Madam Chair. Like unto your questions and that of Senator Corson's, for both Ms. Morgan and or Mr. Kriegshauser, are there protocols that are in place that your association, public health protocols, like, as we've heard from others, the wearing of masks, social distancing, the other public health protocols that have been published, that were this to be enacted, that you feel your association would choose to opt out? Or are you more concerned with, as was mentioned, just the clarity of application of such public health protocols? In short, are you taking those protocols seriously already anyway?
Yes, it's not the public health protocols that we're against. In fact, all 19 of our community colleges, I believe, now are wearing masks. We had one that was a little bit delayed, but we've been doing social distancing, masking, and in fact, in-person education somewhat through this whole pandemic. It's not the health, whatever the health guidance would be, I would guarantee you that our presidents and our boards of trustees would be working hand in hand with the local health officer. It's that lack of clarity, especially as you get away from the metro areas of our state. When we have colleges that don't have full-time attorneys, you have county commissions and local health officers that this isn't what they do every day. It's really the clarity we seek, not that we're not in agreement with the public health measures, because we've taken great strides to implement all of those, and we have mandated masks and all sorts of other things that the K-12 schools in our communities don't have. We still have those. So we're not against any of the public health orders. It's just really about the statutory clarity of, if we have something else that happens 5 years from now, where do we fall in that order?
Thank you, ma'am. Madam Chair, if you will, I think Mr. Kriegshauser is.
Yes, Mr. Kriegshauser, if you're able to answer, and please identify yourself. Thank you.
Yes, Ryan Kriegshauser again. I would say that business has been leading the charge on a lot of these different protocols that are put in place. One of my first clients was a situation under a county order, and the business did everything possible. They were putting up plexiglass before it was mandated. They were wearing masks before it was mandated. It was a large center, and so they put in basically the gold standard as we know it today before it was even mandated. And so I think businesses are conscious. They don't want to hurt their employees. They don't want to hurt their customers. They want people to be safe coming to their business. And so I don't know that government needs to tell them. Another example I'd use is the governor in April issued the church order, and I was part of a group of attorneys that sued on that, and it was ultimately enjoined. And I would note in that order, before it was mandated, is the absolute gold standard in Judge Broom's order that we actually proposed to the governor before we went to court. We sent a letter to the governor's council saying, look, this is what we propose. We are going to wear masks. We are going to have hand sanitizer. We are going to open the doors. We are going to ventilate and have fans to move air through the building. We are going to have traffic patterns. We are going to sanitize the entire sanctuary before. There was at least 15 or 16 protocols that we put in place, and the governor said no. And so we went to court, and she was ultimately enjoined, and the judge put in his order all of those things that we suggested. And I'll add that we went above and beyond the mandates today. And even back then, a year ago, we knew kind of where this would end up, the things that would make people safe. And none of that has changed. It's actually decreased because we sanitized everything, and we found out that really contact spreading, like if I touch this podium, it's still a good thing to wipe it down and wash your hands, but we found out it's not as common as we first believed, whereas at the beginning of this thing, we thought it was, people were wearing gloves and sanitizing everything. And so we believed that to be the case at the time, and so we proposed things to prevent that. So I'd say that businesses, civic organizations, they don't want to hurt their people, and they don't need government telling them what to do when, in these examples, they were leading the charge.
Thank you, sir. And Madam Chair, I'll reserve my comments during the course of further debate. Thank you.
Thank you. Senator Baumgardner.
Thank you, Madam Chair. This is for Heather Morgan. Could you share a little bit about how education occurs as far as concurrent? There are several different ways in which concurrent enrollment occurs for our kids in Kansas.
Heather Morgan, Executive Director of the Kansas Association of Community College Trustees. Concurrent enrollment can be a high school faculty member who we have hired as a community college instructor for a class that happens in the high school. One of our faculty could go into the K-12 building and deliver the class. The student could come to one of our campuses or attendance centers and take the class taught by our faculty. There are times where our community colleges partner with K-12 to use their facilities for technical education for both K-12 and traditional students, and that also goes the other way.
Thank you, Madam Chair. I think that helps share the complexity and that intertwined relationship between our USDs as well as the community colleges. I guess the other thing that makes it different from a business is the notion that community colleges are the taxing entity as well as having a publicly elected board of trustees, and we don't have other businesses that fit under that criteria. I think we would have less of a problem if way back in late 80s we didn't have a particular piece of legislation that passed that pulled community colleges away from the Kansas Department of Education, but now that they are not under that purview, creates an interesting situation. And just so that the committee knows, I have been working with the community colleges and technical colleges. We we do have an amendment that we believe will address those issues. Thank you, Madam Chair.
Thank you. Committee, other questions for our proponent conferees? Yes, Senator Thompson.
Thank you, Madam Chair. For Ryan Kriegshauser. Ryan, I'll let you get up there. It's a long walk.
Yes,
Big room, big room. One of the things that you brought up was about the compensation for intangible losses in Section 10. Did you have, you had a lot of testimony very quickly. Do you have specific language that would address that?
Yeah, in my second bullet, I proposed some language that would fit into.
Real quick. Just identify yourself, sorry.
I'm sorry, Ryan Kriegshauser. In my second bullet in my testimony, I suggest some language that could be inserted into 48933C that defines the word use, the word private property, and compensation. And also, I make a comment that perhaps what they meant by intangible property is speculative damages, like damages on lost profits, things that are harder to quantify. And so if you wanted to get at something like that, I thought the word intangible was a little unclear, but I did suggest some language. And I also did want to clarify an earlier comment. When I say businesses don't mean to be told, I don't mean to say that the passing of information from government to business isn't important. That's very important. What I mean by that is mandates. Just mandating that businesses do certain things. If the government provides the right information, I believe businesses will make the right decision, and so I just wanted to clarify that.
If I may, Madam Chair, just kind of a follow-up there. So if I read this correctly, I think, and this is more of a comment than a question, but you might comment on it, that part of the problem that we have with the current statute is that there's no real pressure to find solutions to end this emergency. And if the government were subject to having to pay losses to businesses, then they may more frequently review that emergency declaration and find a way to end it sooner. Is that your take on this, and do you think that would help?
Yeah, I think that is the point, is that there needs to be some pressure or cost to the government if they're going to impose a substantial burden on a segment of the population on behalf of the general population. And so they should have to pay that small group of people that have that greater burden. And so I think one of the misconceptions is there was a compensation provision that was just ignored by local governments. It's right there in 48933, and we're suing on it now. And so maybe local governments didn't know that there was pressure, that there was a possibility they might have to pay for these restrictions. But under current law, theoretically, that's why we sued, is they might be incurring a bill right now. They just don't know it yet.
That answers it. Thank you. Thank you, Madam Chair.
Thank you. Senator Wilborn.
If Mr. Kriegshauser would hold just for a moment, and this question, and thank you for being here, appreciated your testimony. The perception by many is that there is business interruption coverage on insurance policies to take care of loss of income, but there also is a pandemic exclusion for most of them. Is that correct?
Yeah, oftentimes force majeure clauses in a lot of those insurance policies make it so, wars, pandemics, the kind of things that would the Kansas Emergency Management Act would actually cover, exclude them from coverage under those policies.
Thank you.
Mr. Kriegshauser, I have a quick follow-up question to that. In law, isn't it when you're looking at damages and you aren't entitled to speculative damages because they're too speculative, they can't be proven. Well, my future income would have been this. Well, it's in the future. We don't know what would have happened. So as we're looking at page 19, line 8, regarding intangible losses, if we can, there's a fine line there between, we want to make sure that businesses are properly compensated as provided under statute, but not go into the area of creating a new category of damages that haven't been recognized in law before. So I think that's kind of what the purpose of intangible losses is getting at, but maybe not so correctly stated. And then your input there in your testimony is kind of your recommendation of how we can be more clear about that, if you will.
Yes, Madam Chair, that second bullet, subsection 4, I suggest some language about commandeering or use of any property shall not include loss of present or future profits, opportunity cost, or other extraordinary damages. And so that's how I would kind of define that intangible damages. That's my suggestion.
Okay, great. I see that in the end of your bullet point list there in your written testimony. So,
Yep.
Right, thank you for that. Yes, Senator Thompson.
One more question for Mr. Kriegshauser. If we put, and the language not in here now, and I do have an amendment that hopefully will address some of this, if we deemed that no business could be categorized as non-essential, would that help with this situation, or do you think this additional language would be needed to reinforce that?
I think, Ryan Kriegshauser again, I think that opens a really thorny area, is the distinction of essential versus non-essential. And this really is a paradigm that came from CISA, the Cybersecurity Infrastructure Security Administration under DHS. And they have this CISA framework where there is essential versus non-essential sectors of the society. And we kind of took that guidance here in Kansas and made it into the Kansas Essential Functions Framework. The governor's office did, and started making these distinctions between essential and non-essential businesses. What I've argued is that that is flipping CISA on its head. What CISA, from my work with emergency management over the years, what I understand CISA to be is to push out essential sectors of the society. In a truly terrible situation where there is a 80% mortality, airborne spreading, hemorrhagic fever, this problem will work itself out naturally in that I don't want to go open my gift shop. I'm not going to go try and open my business. I'm going to hunker down and not die. And what CISA says is, look, I'm sorry, you deliver packages. People need to stay home. You are essential. We have to have you go to work. And it's dangerous out there, and you have to go to work. And in this situation here, we flipped it on its head. And you had people who said, I want to go to work, and the government said, no, you're not essential. And we had a situation under, we did a Kansas Open Records investigation, and we got a list of every single business that the KEF team, whatever that is, decided was essential versus non-essential. And there was a situation where there was a 30,000 square foot warehouse. And these people wrote into the governor's office, to the KEF team, and said, we have 100 jobs, and we'd like to save our 100 jobs. We have a 30,000 square foot warehouse. Everyone is working remotely. We need one person in that warehouse to coordinate the supply and just get different supplies to different people to help us save those 100 jobs. And the KEF team said, no, you are non-essential because you make acoustic cleaning supplies. And that should not be the determination. And that's why Section 4 in this bill is so important, because that company should have had the ability to go to a court and say, court, it's a 30,000 square foot warehouse. There's one person in it, and we're going to save 100 jobs. This is not medically necessary and reasonable. And I think the House version contemplates different levels of scrutiny, like strict scrutiny in a situation where you're burdening any business or civic organization. And I think that helps solve the problem. I think the essential versus non-essential paradigm was flawed to begin with in this situation, and it should have been more an operational risk management. You know, that term from my military background is very common in a war situation. It's a dangerous place. You're not going to eliminate all risk, but what you have to do is succeed in your mission. And so you apply operational risk management principles, and you do what you need to do to stay as safe as you possibly can. And that seems to make more sense to me in this type of situation than go to the far field of saying we're going to classify small businesses non-essential and Target that sells the same goods as essential. You get into these situations where people intuitively say that's not fair. And I think that got us off on the wrong foot through this whole thing. I think if at the beginning there was a pause of 2 weeks to figure out this came from Wuhan, there's a virology center there, we don't know what this is, let's take a pause, see how dangerous this is, and then you say, okay, we know what we're dealing with. Everyone needs to wear masks. You need to socially distance. Everyone open up. We're not going to tell which businesses can and can't, but everyone needs to follow these protocols. I don't think you'd have the same pushback and the same politicization of the situation that you see now. I think having those inherent unfair distinctions at the front end really caused a lot of this politicization.
Madam Chair, if I do have an amendment, but I think that if I worked with Mr. Kriegshauser, it might improve that amendment quite a bit. So I'll probably be in contact with you, Ron.
Yeah, happy to answer any questions from any committee members.
Thank you. Senator Pyle.
My question is for Ryan Kriegshauser. Ryan, I've sat through 6 days of meetings on this, and we've got a bill in front of us that's, I don't know, 20 some odd pages long, small book. And by the time it gets through all the amendments that are coming to this committee and the time that we're going to take, I think this thing's destined for a veto anyway. But I'm just curious, because you mentioned the business issues, you mentioned some other things. To me, after hearing all of this, there's a solution. And the simple solution, in my estimation, is what I've proposed in a concurrent resolution 1604. Give the people the power to petition to call us into session. Do you believe that the businesses would have passed a petition to call the legislature back into session to deal with this problem? Is that a possibility? Is it real? Would the people out there that oppose the mask mandate have risen up and called this legislature back into session earlier? I want to know. I want to hear, because I'm hearing that they would. And right now we have executive power. The governor has the power to call us back into session. It takes 2/3 of these two chambers, House and Senate, to call us back. And yet we come in every morning and it says the political power is inherent in the people, yet the people do not have the right to call us back into session. And people say, oh, you don't want this group or that group having the power to call us back.
Yeah,
I want to hear your opinion on that policy process, because I think that policy process solves all of this. And it holds the executive in charge of this state accountable to the people, so that the people then are the check and the balance on the executive, because they call us back and, by golly, then put the pressure on us and we stop it. Because they are screaming for this declaration to end. And yet, here we are, 20 some odd pages, going to be here who knows how long with all these amendments, and yet we could address this issue very simply with a constitutional proposal and let the people, you know, that's a delay, I understand, but we could pass a constitutional amendment and put it on an April ballot. We could put it on a ballot in 60 days and resolve this, because that's what elected officials, they should be held accountable to the people. I just want to hear your opinion on that, please.
I appreciate the question, but we need to stick and be germane to the bill that we're hearing, and I understand the senator's question. So if you can answer, you know, related to the bill that we're working and not another proposal that's not in front of the committee right now.
Sure.
Thank you, Senator.
I appreciate the question, because you bring up two points, and I'll defer to Eric. I don't know if he's still here, on what he heard from his members about whether or not they wanted to call the legislature back, because I don't know. He'd be the better person to answer that. But the second point is, you bring up one of the hardest parts of this bill in the legislative delegation issue. And I think this bill tries to solve that by creating this joint committee. On the House side, they set up the I think it was the LCC, switching it from the State Finance Council. And so you highlight a point that is very pervasive in the bill, and that legislative oversight must be robust and it must be present. And to what extent can the legislature delegate its authority to the governor, and for how long? And I think the Attorney General's testimony has some points on that here, and I defer to him on the extent of because it's a really deep rabbit hole, the legislative delegation doctrine, and so I defer to his testimony that whether or not this bill adequately addresses that issue.
Thank you. And Madam Chairman, I would differ with you. The germaneness of my question was absolute in sense, because the joint committee that we're trying to put together is a way of check and balance on the governor. So what I've proposed in other legislation is relevant because I've sat through all the committee hearings. And if nothing else comes out of this bill, and what we ought to do is probably gut this bill and just put the joint committee in there and see if we can get that to fly. Because all of the other details in here are going to occupy so much time and so much controversy that it's going to probably make this thing so it can't fly. That's my opinion, but I do believe what my questions are germane because I think the answer to the solution is the people of Kansas, and they need to be the ones that answer this question. And so thank you with all due respect, Madam Chair, but I do believe he pointed out how it did apply, so thank you.
Thank you, Senator. And I think we're all in agreement that the power in these emergencies needs to rest with the people of Kansas, and that's why we have Senate Bill 273 in front of us without commenting on any other legislation that is not currently before the committee. Those are valid points to take up when discussing other bills that would be before the committee that aren't currently before the committee. So we need to be following the procedure. This is the legislative process where we have a bill in front of us. We're hearing that bill, not another piece of legislation or proposed bill. So that's why questions back on the topic of this particular bill. Any other questions from the committee for our proponent conferees? Seeing none then, thank you for appearing in person to our all of our conferees. Appreciate that and your time and your thoughtful testimony. We will then turn to, we have a neutral conferee. We will invite Ed Klump from the Kansas Association of Police Chiefs and Kansas Sheriff's Association and Kansas Peace Officers Association. Mr. Klump, please identify yourself and welcome back to committee.
Thank you, Madam Chair. I am Ed Klump. I am here representing the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, and Kansas Peace Officers Association. I'm going to zero in on one particular issue in this bill that concerns law enforcement directly, and I want to preface that with this comment. We appreciate the direction Senate Bill 273 is going to restore the Emergency Management Act the way it was prior to COVID for those emergencies that have nothing to do with a health emergency. That act had worked wonderfully for us for years and years and years. But in the process of amending that act to fit the health emergency, we broke it for the other emergencies, and that's what I'm here to talk about. So specifically, if you will go to page 19 on lines 14 through 30, I think it actually runs down through about 33, is the provision about the violations of the act and the penalties to that. Prior to COVID and the amendments that were made last year to the act, a violation of an order was a Class A misdemeanor. During COVID, we all recognized, including the legislature, that health emergencies are very uniquely different than other emergencies. But in the process of that, it was a desire not to have us taking people into custody for health emergency orders, and we agree with that. However, what the amendment we are proposing to you is in the bold print starting at the bottom of the first page of my testimony. And what it will do is it will restore the Class A misdemeanor for all of the emergencies that are not health related. That's very important to us, and let me explain why. Generally, orders that we would have this issue come up with involve things like tornadoes, civil disorder, floods, fires, and things like that. The two most common types of orders that get created that bring this into play for us are curfews and limiting the public access to certain areas where it's been damaged. And we need those tools to prevent looting, but also assist us in assuring public safety. In many tornado situations, we have gas leaks, we have live power lines down, and many hazards. We need to keep people out of there until we get those things stabilized. Then we like to open it up to the residents or the business owners or the property owners that have property in that area and keep everybody else out because we want to keep the looters out. And every time we have one of these incidents, I don't care what size town you're in, we have a looting problem. It always happens. So with the law in the current state it's in right now, it's a civil penalty if that curfew is violated. And here's the problem that poses for law enforcement. A civil penalty is not a crime, and that was the intent of making it a civil penalty. It wasn't a crime. But in KSA 22-2402 is our authorization to even stop a person and make an investigative stop to inquire of their conduct that has led us to believe they are either committing a crime, about to commit a crime, or have committed a crime. And without a crime, we have no authority to stop that person and make those demands of them. We have no authority to make that investigative stop. We have no authority to stop a potential looter that's wandering around an area we've closed to the public to protect the property of the victims of this disaster. So all we're asking is to form a two-stage replacement for this section of the bill. One would be it would restore the Class A misdemeanor exactly the same as it was before the COVID amendments for all of those emergencies that are not health-related. And it retains the civil penalty for the health-related emergencies. So it doesn't change what we're doing for health-related emergencies, but it gives us that very important tool back to us for the non-health-related emergencies. And I can assure you, sometime this year, we are going to have a tornado or a flood or something that we'll have one of these incidents at. So my request for you is to consider that amendment. It is very important to us. It's very important to our ability to protect the public and to protect their property in the case of these emergencies that are not health emergencies. And the other point that I want to make is on page 20, lines 10, there is a provision in there that amends the definition in the Emergency Management Act for emergency responder to include our 911 center dispatchers. This is a very important provision to us too. We had trouble getting personal protective equipment for our dispatchers in those dispatch centers that were not under a chief or a sheriff or a fire agency, and because of this definition. So we just want to clarify that in an emergency that they are also able to get assistance through the Emergency Management Act. And I'll stand for questions.
Thank you. We will ask then, are there other neutral conferees in the committee meeting room or on WebEx? Seeing none then, committee, any questions for our neutral conferee? Yes, Senator Wilborn.
Thank you, Madam Chair. Just for clarity and openness, I do have the amendment prepared with the help of Mr. Klump to correct what he has asked for at the proper time. Thank you.
I'm sorry, did you have your amendment turned in, Mr. Klump?
It was in our testimony, and I sent that testimony to the revisers so they would be aware we were making that, because I knew what fast pace this would be at, and I did have a conversation with Senator Wilburn about it. Thank you.
Okay, very good. Thank you. Committee, other questions for our neutral conferee? All right, seeing none, then thank you for appearing in person and for appearing today and with your time and your testimony. Appreciate that.
Thank all of you.
Committee, then, please note that in your committee folder, we have neutral written testimony from Mark Tallman, Kansas Association of School Boards, and Dennis Kreisel, Kansas Association of Local Health Departments. With that, then, committee, we will then turn to our opponent conferees. We will start with Mr. Will Lawrence, Chief of Staff to Governor Kelly. Welcome back to committee, Mr. Lawrence. Please introduce yourself.
Thank you, Madam Chair. Will Lawrence, Governor Kelly's Chief of Staff. First, thank you for extending the hearing this morning. I do appreciate that, and that was certainly part of our concern. This is a fairly comprehensive bill, and think the time needs to be spent to really dig into some of these issues. We have not had a chance to go through all the bill in the way that I'd like to address a number of the issues, but I'll address some of the probably the larger issues and focus also a little bit on the declaration, because I think at certain points we get into this back and forth of the declaration versus emergency orders. And while one allows the other, they are separate and distinctly important. The first thing I would point to is that the context in which this is all being considered is really important. And I mentioned this last time I was before this committee, that we are still in the pandemic. It is not over. And while we see light at the end of the tunnel, and we are all very hopeful that this will be over soon, we still have to move forward with the distribution of the vaccine. And that's going to take time, and it takes a big involvement in the state, working with our local communities to get that done. And I lay some of that out in my testimony a little further, but I checked last night, and to the best of my knowledge, every state still has an emergency declaration in place. And that's really, really important. I do note that I don't think in this bill it addresses the current declaration and the extension thereof, but that is something that needs to be addressed, because March 31 is not very far away either. And so I won't go into all the details on that here. It's in my testimony, and I do touch on all of the resources that we have provided over the course of the last year, and all the things that will go away if this were allowed to expire, including the using of the members of the National Guard in the distribution process for the vaccine. But I think a key point I will touch on with the declaration and why it is so important is that, the Kansas Response Plan is how we respond to all emergencies. So the declaration issued by the governor is what then gives the Adjutant General and the Kansas Division of Emergency Management the authority to open up and use the State Emergency Operations Center, or the SEOC, to begin responding to the emergency at hand, whether it be a flood or tornado, fire, or pandemic, or any other type of emergency. And a number of the state agencies are all included in there as emergency support functions and have different leads based on the issue at hand. And so KDHE is an ESF partner. They're the lead on the annex dealing with a pandemic. And so they are certainly the lead on those situations. And that's really, really important, because if that goes away, then we lose the ability to move resources, to mission assign people from agencies, and work together in a cohesive manner at the state level and with our local partners in their communities to coordinate resources and help in the situation at hand. And that's very, very, very important. I mean, we have a call with all 105 emergency managers every day. We've been doing it since the beginning of this, and we're zeroing in on a day 350 of the response. So I point that out as we talk about this, and we're looking at making all these changes. And then Senate Bill 273, we're going from, we have what appears to be all the emergencies except for public health, and public health is a whole separate ballgame. And I'll point out why we have some concerns about that that probably need to be contemplated. And the big one that I point to is, again, going back to the Kansas Response Plan, if we had an issue with Wolf Creek Nuclear Power Plant, if we had a radiation leak or exposure, that in the state response plan is going to be, would fall here under the public health disaster or emergency, however you would define it. And so the process in which this bill lays out the joint committee and having to have orders by the governor pre-approved under a public health disaster, it's going to be a problem, because you're going to have a mandatory evacuation that's going to happen immediately. You're going to have to select which routes people go through. If there's been exposure to crops, those crops are going to have to be embargoed, and it's going to have to be in that radius of where the cloud of radiation went. And if people need to move livestock, there needs to be able to have the ability to do that. Under our understanding of this bill, the executive order from the governor making those directions would have to be first submitted to the Attorney General who would have 24 hours to review, and the governor could not submit that executive order to the Joint Committee until that 24-hour time frame had expired. Then that committee has 24 hours to call a meeting by the chair. I do note that this doesn't say that the meeting has to happen in that 24-hour period. It has to be called or scheduled is how we would interpret it. So that would certainly need to be tightened up, but we're still talking about a fairly long delay in an emergency situation. And that's, I think, a key point for us in this is the legislature absolutely has to have oversight and has to play a role. We don't view KEMA as solely a delegation of legislative authority to the governor. It is a blending of both because the governor does have the authority and vested in her as the chief executive of the state, and that does include responding to emergencies. I've addressed that in previous testimony, so I won't go into the details of all those things, but I can provide that testimony as supplement to mine if anyone's interested in seeing that or seeing it again. But that blending is really important, and we have to be very careful that in emergency situations we are not putting a committee or a group in the situation where they are the decision maker in an emergency. The emergency has to be dealt with quickly and swiftly, and this feels different. And we're thinking about this in the context of a pandemic, so we've been doing this for a year. And most emergencies don't last that long, but we have to remember that sometimes it's going to happen. This is a very rare circumstance, but we can't write the entire act or make these broad sweeping changes thinking about just the pandemic and not think about this from a global perspective. So we would still advocate that whatever changes are made to KEMA at this point in time are very narrow and targeted because we're still in this pandemic, and we need to probably have a very thorough vetting of any major changes after this is over. And so that's what our biggest ask would be. One thing I would point out that I think would be helpful is I think in here it's still 15 days for the initial declaration. That's not a very long time. If you think about the emergency that just happened last week, we've had some counties that have asked, can we extend beyond the 28th of this month, and because they would like that to potentially happen. We're not sure that's going to be necessary, and we've been talking about that, but then we'd have to go to Finance Council and go through that process for an extension when 21 days, 28 days may have covered that. So extending that time frame a little bit would probably limit the amount of times you have to ask for an extension, but still ensure that there is proper oversight if you're going to go beyond, a 21 day or something like that, because the issues with floods, fires, tornadoes can sometimes go well beyond, and we've seen that. We had floods 2 years ago now, I think, that the declaration went on for a very long time, and that was because we were hauling water to one community. So I think those are the key things that we'd point out from the broad strokes of this bill. And then I will be happy to stand for any questions regarding further pieces that individuals would want me to comment on.
Thank you, Mr. Lawrence. Appreciate that. And we'll go ahead and, like we do with our other conferees, have the opponent conferees and then open it up for questions. Appreciate that. With that then, committee, we will turn to our next opponent conferee, Dr. Lee Norman, Kansas Department of Health and Environment, who is appearing via WebEx. Please introduce yourself and welcome to committee.
Thank you, Chairwoman Warren and members of the committee. This is Dr. Lee Norman. I'm the Secretary of the Kansas Department of Health and Environment and also serve as the State Health Officer of Kansas. In those roles, I'm of course greatly concerned about protecting the health of the public. Our agency scrutinizes legislation which would affect those obligations. In fairness, I think that Senate Bill 273 is a bit rushed and looking at changes through purely the optics of a recent and ongoing COVID-19 pandemic. And I'd like to present, in addition to the written comments, a few verbal comments here about that. KDHE would favor a more deliberate discussion analysis of not only our recent history of COVID-19, but also with prior public health events like H1N1 in 2009, Ebola in 2013, flooding, and some of the public health hazards that occur from that. Each of these prior events posed challenges to public health authorities. We should not ignore the lessons from these events. I'd like to talk about a few Kansas-specific examples and talk about how this bill would interfere with the responses. One is about COVID-19. You may remember at the very beginning, there was that large cruise ship off the coast of California that was at anchor. People were there for a long period of time until the federal government could figure out what to do with them. And indeed, they eventually disembarked, were rather quickly processed. And then unbeknownst to most Kansans, I think, there were a bunch of Kansans on that cruise ship, and all were exposed to and or ill with COVID-19. The federal government let us know that if we would assist, that we could bring them back to Kansas. And of course, we wanted our Kansans to return home, but we wanted them to return home safely, both for their safety and for our citizenry. So the federal government didn't do anything except arrange private air transportation to two airports. One was in Wichita and one was in Kansas City, Missouri. We were concerned that if they were just landed and got off the airplane, that they could disappear into restaurants, bars. They'd been cooped up for a long period of time. And we thought that was a very bad idea since they'd all been exposed or ill with COVID-19. So what we did was, what I did as secretary was issue quarantine orders that were mandatory quarantine orders. We didn't end up having to issue them because instead we took a negotiated approach with the local health officers, and we helped these people get the refrigerators stocked by friends and family. We met them at the airport with a van with our agency personnel in full PPE, and we had law enforcement quietly there to assist to make sure that these folks going to their many different communities arrived there safely. Everybody arrived there safely and finished out their quarantine order. But you can imagine, and we hadn't had a case, I don't think, in the state of Kansas yet at this point, what that would have caused having these many people go to many different communities without having that kind of assurance that they would be managed in isolation and quarantine safely. So we did not have to use the quarantine order. Let me give you another example, mumps. There's still mumps out there. We had a situation in Southwest Kansas where there was a person in a jail and about 8 or 9 other people around him, but the person had mumps, active infectious mumps. And a lot of people don't have immunity when they get into adulthood for mumps. And the jail could not tell us what the dispensation of this one ill person and these other exposed ones was going to be. So I did issue quarantine orders so that they were isolated in quarantine for the full period of time, because otherwise they could have been released from jail that day. They might have been sent to a different correctional facility or put out on a work release program. Would have been very inconsistent for somebody with mumps or exposure to mumps. There's another example of I got a call one night of an abandoned baby in a hotel. The baby was brand newborn, wasn't even washed off, and was still attached to its umbilical cord and placenta, and no woman was there. She'd basically taken flight. The baby was taken to a hospital and evaluated and found to have congenital syphilis. Congenital syphilis babies oftentimes die in utero or shortly after, but this one survived. They oftentimes have neurologic and other kinds of conditions. We tracked down with the help of law enforcement, and not only, because I have the authority to issue an order that a person be tested, she was tested and of course found to have syphilis, and she was then cooperative, went into treatment, but without the authority to issue a mandatory isolation and quarantine, she very well, after being tested for syphilis, could have disappeared into the woodwork. And I can tell you, with her chosen employment, she would have placed many men, particularly, at risk for this ongoing spread of syphilis. I can say the same thing about tuberculosis and HIV. We know there are people that are positive for HIV and tuberculosis who will continue.
Dr. Norman.
Yes, ma'am.
I'm going to call a point of order here, if we can. We've been trying during our hearing today and yesterday to stay on the bill, Senate Bill 273 and its particular components, and I appreciate the examples that you're giving, but we're trying to move efficiently as well. So if you can stick to Senate Bill 273, and I see in your written testimony that you have submitted to the committee that you do talk about a couple of aspects that are concerning, and let's please try to keep it germane to the bill that we're working on.
Okay.
Thank you.
Happy to do so. What the Senate Bill 273 would do with these particular situations I'm talking about would have they would have disappeared into the woodwork, and those people would have continued to expose other people. I can pretty well assure you that if I had to submit for permission, or I should say review and approval by the Attorney General or by a committee, that I would not have the ability to respond, as Mr. Lawrence pointed out, in a rapid fashion to the immediate infectious emergency. 273 would be an obstruction to that. That was the reason I wanted to point out that this goes well beyond COVID-19, but between TB, HIV, pertussis, measles, there are times when we have to quarantine people and we cannot delay. They will disappear back into the woodwork. Final comments are the ones are more technical in nature in the written testimony that needs to be broadened beyond human-to-human transmission, and the concern about a declared public health emergency and the effect on the drawdown of federal dollars, which is quite helpful for counties. Those two paragraphs are pretty self-explanatory. In summary, we don't support this bill. We're supportive of the idea of reviewing this in a more measured manner. We didn't hear about this bill until yesterday evening, and I think that this is a hurried attempt to achieve something, but it won't achieve a strengthening of our public health system, and because we have very strong Kansas statute that's been in place 100 years. With that, ma'am, I will stand for questions when appropriate.
Thank you. Committee, we don't have others listed for testimony today, but I will ask, are there other opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then we will open it up for questions from our committee for our opponent conferees. Senator Haley.
And thank both Mr. Lawrence and Dr. Norman for being here. My question is very brief but comprehensive, Madam Chair, for Mr. Lawrence, if he might. Two quick things. My ongoing concern, and again, thank you for being here today, sir. So I live in Kansas City, Kansas, of course. Kansas City, Missouri, most recently, has changed many of the dynamics for specifically restaurants. And it has created, or it could create, an imbalance in small businesses and trade by changing those dynamics. So my question, sir, to you, because it is a major concern to me, is you referenced in your testimony that there's still 50, or that most states still have a plan in place. Is there any cohesion that looks at the regional balances or imbalances in our emergency plans that come out of the governor's office that might take into account the impact of surrounding states, specifically in our region? Were these plans to be implemented? If you understand what I'm asking, because between Kansas City, Kansas, and Kansas City, Missouri, even though both may have emergency plans in place, there is a shift that can impact our small businesses, both essential and non-essential.
Will Lawrence, Governor's Chief of Staff. Thank you, Senator, for the question. And the answer is yes, and we saw it kind of in a variety of ways at the state level and at the local level. During the last spring, the counties along the border, particularly in Kansas City, were working together to try to come up with joint orders that were all issued by the different jurisdictions, but tried to stay in line with each other so that there was consistency across the city and across the state line. And we also stayed in touch with governor's offices in Missouri and in Nebraska and Colorado, and just a little bit briefly with Oklahoma. We didn't have quite the same issues with Oklahoma where there was needed to be more coordination. But so that is certainly done. We also, I know Dr. Norman was talking to his counterpart in Missouri quite a bit, and emergency management does that as well when necessary. They have organizations that, are national organizations that look at these issues as well. So there's always an attempt to have that coordination where at all possible. I don't know of any, federal laws that would deal with directly that type of coordination. It's all done through the Stafford Act and other emergency management acts, and each state handles their own jurisdiction through those statutes.
Thank you. And Madam Chair, a brief follow-up. I tried to catch the press conference that the governor and Secretary of Commerce, Secretary of Treasury, Lynn Rogers, were having as this meeting was beginning. Downstairs in the rotunda, a piece of it was speaking to banking made available to those businesses who may have been damaged. I think some of the issues that have come up by members of this committee in terms of tangible losses and the questions of intangible losses. I didn't quite catch it, but if you are aware of what that press conference, I think that was called at 10:30 this morning, where your office was involved, and how it may apply to offsetting some of the concerns here in 273 about the ability of compensation to be forwarded to identifiable losses among businesses. If you're not aware of it fully because you're handling this, I understand, and perhaps I'll just have to get the press release or the briefing that will help me understand how we apply those economic damages or address those economic damages to small businesses, either through that press conference or in this bill.
Will Lawrence, Governor's Chief of Staff, that's Senate Bill 15, the bankers bill, as it's referred to, that was being signed. So I would probably redirect away from that particular issue and how it's connected here, but would point you to, we're talking about the emergency response and everything that goes with that, and there are some provisions there, but also don't forget that we have the Recovery Office and the CRF funds that provided programs to help a lot of people that were going through the different aspects of the results of the pandemic. And so I would point you in that direction.
Thank you for that clarity. Thank you, sir. Appreciate your being here today. And if I could, Madam Chair, I am supportive of having a central office, one major office with legislative review, but certainly work in concert with other offices to make the core directive that we can hone. So I just wanted to clarify. I know the chair had made that point that we all felt the legislature should be the fort. I am not of that mind. I do believe there should be one central office that works in conjunctions with other offices around the country to understand what the best practices are and then have legislative oversight to follow. Thank you, Madam Chair, and thank you again, Mr. Lawrence, for being here today.
Thank you. Senator Wilborn.
Thank you, Madam Chair. Traditionally, I keep my comments brief and my questions brief. And first of all, thank you for being here. And on a personal note, I want to say appreciate the work you've done to help my constituents in my district. Your work has been invaluable, so I want you to know that publicly. Secondly, I think it's important that the governor recognizes that the legislative branch has a co-equal part. I think the recognition of that is very important going forward. And I'm going to ask you a rhetorical question. Looking back over this pandemic, can you cite some instances where you wish you would have done differently, the governor's office?
Will Lawrence, Governor's Chief of Staff, and thank you, Senator Wilborn. Always happy to be helpful where I can be. Of course, I would tell you that over the course of the pandemic, I think there were I can't imagine there's anyone that thinks that they handled everything perfectly. That this has been a monumental challenge. and certainly not something that I anticipated having to handle when I took this job. And I think that's true for the governor as well. But there was no playbook written for this. And so you handle things in the moment, and you try to make some of the best decisions, and every state was making decisions a little bit differently. So you certainly look to your counterparts. We look to the National Governors Association for guidance, and we look to the federal government for guidance, and got some of that. But and states are doing a lot of the same things with different components that were specific to their state. But certainly, absolutely, there are plenty of things that we could have done a little bit differently here or there. There are certain things in the statute that we also agree should be addressed and be changed. But again, we think that this should be done in a very narrow, targeted approach right now, because we are still responding to this emergency that, again, we also want to end as soon as we possibly can. But that time's not now.
Thank you.
Senator Thompson, then Senator Baumgartner and Gossage.
Thank you, Madam Chair. Actually, this is for Dr. Norman. Basically, with regard to quarantines, local health officers can, and you, I believe, have the authority to do so under Chapter 65. So why, these emergency orders, you have this, even without the emergency, you would have that ability, would you not, to quarantine individuals for mumps or flu or anything like that? Just wondering about that.
Go ahead,
Yes,
Dr. Norman, please identify yourself. Thank you.
Yes, this is Dr. Lee Norman, Secretary of KDHE. And the answer to that, Senator Thompson, is yes. It is the 65 series of KSA that allows for investigating, quarantining and isolating, or testing, and that can be done outside of an emergency. Absolutely.
So I guess my question maybe for you and for Will Lawrence, either one, what is the metric that we're going to use to end this emergency? And I realize it's not necessarily germane to the bill, but to some degree it is, because we're dealing with an emergency, and I'm looking at the KDHE website where the case rate is now dropped to lower than what it was last June. And yet we hear from the governor's office that this emergency is not over. I'm just wondering, when will it be over? This is not me. I've got a lot of constituents who are asking the same thing, who want to get their businesses back to normal. And after a year, if people don't understand the protocol for staying safe, how long does it take to educate people?
Yes, this is Dr. Lee Norman, Secretary of KDHE. There's no bright line, Senator, that says now it's safe and or now it's continued to be unsafe. I do know that we're still having 1,000 cases a day. Every couple of days we have 60 to 80 more deaths. So we still have a ways to go. We do know that when the percent of positivity of the number of cases drops, that it gets more safe all the time. For example, and with a broader rollout of the vaccine, safer all the time. Over 500,000 Kansans now have received at least their first dose. But I do not have in front of me a bright line that says this is absolutely the day, this is the tripwire that says we're safe. And I think that the right approach will be measured, and it will involve a broad constituency input. I'm glad to see us getting back into in-person teaching in schools. I think it can be done safely with certain modifications. And I have said all along, and agreed with our person from the chamber, that the safer we make the businesses, the more they'll thrive. So the intent of this agency is to do everything we can to return to normalcy.
Thank you. Mr. Lawrence, did you want to respond?
Yes, thank you, Madam Chair. Will Lawrence, Governor, Chief of Staff. I would agree with Dr. Norman. There is no bright line. Again, what I would point to is I think there is a distinction between the orders, like the face mask order, and some of the county orders that are putting in curfews or restrictions on business, which those are all local orders. The governor has a statewide face mask order. But outside of that, any other restrictions are coming from the counties. But outside of that is the declaration. The declaration allows that order to happen, but so many more things come with that declaration. And I kind of touched on those in my testimony. I mean, even as simple as the non-congregate shelter that we provide for people to be able to do isolation and quarantine. And these are our healthcare workers, our first responders, and those that are responding to that. Members of the National Guard are transporting test specimens to KDHE lab, doing some of the testing, and also doing the vaccine. And so there's a lot of things that go with that. And pointing back to the flood example, we hauled water to one community that did not have water based on the flooding of 2 years ago. For a very long period of time, we had to have the declaration to be able to do that. And it's for some of the same reasons laid out in my testimony.
Thank you. Senator Baumgartner?
Thank you, Madam Chair. Will, thank you for being here today. My question is the issue that you addressed, your concern about a 24-hour wait period. And so I guess clarify for me, the 24-hour, the governor, if she or he is wanting to issue an executive order, it's the executive order that would go to the AG for review and then would go to the committee. But as far as, you know, the example that you had given, if we had a problem with nuclear power plant or something, that declaration of a disaster would and could be made immediately. This bill does not prohibit that. So explain to me the concern about a delay of time, because I don't see a delay of time.
Absolutely. Will Lawrence, Governor's Chief of Staff, and thank you, Senator. The issue is not with the declaration. The declaration would issue immediately. But should the governor need to issue an executive order, and I provide a couple of examples of what that could be, that, you know, if there needs to be a mandatory evacuation with a certain route, the likely scenario is that would be done in an executive order to make it clear that that's how that needs to happen. Same thing if there needs to be an embargo on crops or things of that nature related to that emergency, that would need to be done by an executive order. My reading of this legislation, and I'm looking for, it looks like, I think it's on page 4 of the bill, is where it gets into the executive order piece and its interplay with the Attorney General's office and this joint committee. And we've certainly been using the Attorney General's office from day one of this in sending these things over for review. And certainly that is important. But the idea of having to wait 24 hours to move on something like that, I don't think that's the intended consequence here. In this type of an emergency, because we're thinking about the pandemic, but it's an example of something that could get caught up because that type of emergency under the state response plan is a health emergency, not an energy emergency or other type of emergency. It's a health emergency.
Thank you. And Madam Chair, I guess I would simply say it has to be done within 24, but depending on what it was, depending on what the issue is, I think this is simply trying to codify that it will go through a process other than just the governor's office. And let's just say we had a particular emergency, like the one that you described. I think it's entirely reasonable that these two next groups that need to be communicated to, the Attorney General's office as well as the other group, would not be sitting there and waiting for 24 hours to pass, but would be expedient with regard to the nature. But I think that we can say, in looking at hindsight, there have been some executive orders that didn't go through that process that perhaps might have been modified if it had gone through that process. So certainly you have an understanding that there is the desire to have a process whereby it's not just the executive branch, but another branch is involved in the process.
Will Lawrence, Governor's Chief of Staff. Madam Chair, if I may respond.
Please.
I guess I'm not going to, I don't believe in saying absolutes because you can always point to one time that maybe I'm incorrect. I'm unaware of any times that an executive order issued under COVID was issued that did not go to the Attorney General's office for some level of review. Obviously, it may have been in a very tight turnaround, and we tried to get as much feedback as possible. But I'm unaware of anything that didn't go through that type of process that we set up. And I'm not saying we're opposed to that type of process. I think what we're opposed to is a process where it has to be pre-approved before it can become effective, as opposed to being reviewed even in that short period of time. And I think, and it could be the way that we're reading this, but on page 4, starting on line 11, under 3, it says not less than 24 hours after submitting the proposed executive order to the Attorney General. That's where we're reading that. I think we have to, under this, have to give the Attorney General's office 24 hours to review. And maybe I'm misreading that, or maybe there needs to be some clarification there. I haven't had a chance to ask questions about the language in this bill to where whoever is authored by to understand that. But that's where we're reading that. If that's the case, we have to wait 24 hours. You know, I'm not saying people are sitting on it, but this says we have to wait 24 hours before it can be submitted for the joint committee to be called.
Thank you. I see within 24 hours, not that we have to wait 24 hours. It says within 24 hours of receipt that it will be called. And I think it gets back to the issue of some of the executive orders. Every executive order, I think we can agree, does not have the same impetus or the same sense of this must be done immediately as to this is the ask. So I would like to think that depending on the actual disaster, there would be, some things would be addressed quite expediently by not only the Attorney General, but also by committee. And so I don't see that as a deterrent. And Madam Chair, my second question is for the Secretary.
Thank you. Dr. Norman, are you available to answer?
Would you repeat this is Dr. Lee Norman, Secretary, KDHE. Would you repeat question 2?
Haven't asked it yet.
She hasn't asked it yet. I just want to make sure you were still there on WebEx. Thank you.
I am available, yes.
Sure, go ahead.
Okay, thank you, Madam Chair. So in your testimony, you talked about mumps, you talked about STD, syphilis specifically, and you even used an example of those that were on a cruise ship with COVID. So I just want to clarify, because what you were originally told us is that with Senate Bill 273, you could not quarantine on those issues. Are you now changing your position that yes, in fact, you could address quarantine for mumps and for STD? You could, in fact, do that regardless because it would be outside of Senate Bill 273.
Yes, this is Dr. Lee Norman, Secretary, KDHE, and thank you for the question. I can do it now, and the question I have is whether there's anything in this bill that we first looked at starting last night, if there's anything in the bill that was intended essentially, I think it's written to cover COVID-19 and this pandemic, but is there anything in this bill that would impede the ability to do the things that we've done for a very long time with our public health statute? When it talks about the review is required by the Attorney General, for example. And, you know, at least Senator Scuffin said he plans to clarify, or somebody does, what accepted science is. Until I feel comfortable with knowing what the bill means by accepted science, because it's not articulated in there. I don't know what that burden of proof is, and if that would interfere with the ability to do isolation, quarantine, testing, and the like. So I think there's enough ambiguities in this bill that I don't have any degree of comfort that those other things wouldn't be touched by it.
Thank you, Madam Chair. I just have to say, I don't think that the examples that were shared with us at the beginning of the testimony in any way would be touched in any way by Senate Bill 273. Thank you, Madam Chair.
Thank you. Senator Gossage.
Thank you, Madam Chair. Will, thank you for being here. I have a question for you. You had mentioned in your written testimony and that Governor Kelly issued an emergency declaration on March 12th of 2020, and this was under the Kansas Response Plan. That was due to expire on January 26th. So this body expanded that and extended it on January 11th. That was signed by the governor to extend it to March 31st. So of course we recognized that it needed to be extended. However, we also realized that this original emergency response plan was by and large designed for shorter durations. None of us have ever experienced anything like COVID. And so that's why we are looking at 273 and giving a very deep dive about what needs to be done, and have been working on it since January the 11th. So my question is, would you agree that there are lessons that have been learned under COVID and that the Kansas Response Plan should be amended based upon what we have learned?
Will Lawrence, Governor's Chief of Staff, and thank you, Senator, for the question. I would not agree that the response plan needs to be the focus, and that's not the focus of, I think, 273. 273 is the Kansas Emergency Management Act. The response plan is the document that kind of coincides with that it goes through the process with the Kansas Division of Emergency Management that governs how we do all the things. And that's, there's an annex for this particular issue. It has how we interplay with the different agencies and the locals and all of that. And so I don't think that's what we're talking about here. Obviously, that goes through a review. I think every 2 years it goes through an exhaustive review and process, and it looks at all the different emergencies. But I think what we're talking about here is not changing the response plan. We're talking about changing the KEMA, which deals with, and the focus continues to be more about the executive orders than the declaration. But the declaration is what triggers that response plan that has all of our agencies doing their different parts to respond to the emergency.
So in response to your answer, which I appreciate, if we were to amend this, which we're working on right now, which would be the emergency management, the name of this bill, as we're working on this, and you were saying you felt like it was rushed and that you just got it recently, and we of course are going to be amending it even more as we work this bill in committee. And I was interested in if you would be providing, in addition to your testimony, anything from the governor's office after looking at this that you would like to see amended, and if so, when will you be sending that over?
Will Lawrence, Governor's Chief of Staff. I'm happy to provide some additional information. I did let the Senate President's office know yesterday, I think it was yesterday morning, that we were going to send out a proposed bill. I think it was maybe introduced this morning to show kind of where we're at. I will tell you it tracks very closely to current law with some changes to the amount of time for the initial declaration. But in terms of the substance of 273, I mean, I don't know how you, particularly how you divide it up into two separate, everything else in public health. I'm not sure that we have any changes that would make that new section something that we think is going to be acceptable. We think it should all stay under the current KEMA statutes. And, I think the House version, which we certainly have concerns over, but I understand the way they've done it is they focused on C11, on those authorities related to kind of the catch-all provision for executive orders, is a little bit more targeted in its focus. So I think that may be a little better approach than creating a whole new section of area that, I think it's good to hear that the belief is that doesn't impact Dr. Norman's other authorities as Secretary of KDHE. It was unclear initially if this was intending to amend all that or alter that because of, this is pretty hot off the presses in terms of this concept to our office anyways.
Thank you. I appreciate your opinion. In If I may, Madam Chair, just one question for the Secretary.
Sure, yes, please,
Dr.
go ahead.
Norman.
Yes, ma'am, I'm here.
Thank you, Dr. Norman. You mentioned Section 65, or Article 65, and said that it gave you the authority to isolate, test, and quarantine. One of my constituents asked me a question about this very thing yesterday, and the question was, does this give authority to quarantine healthy people?
To quarantine, I'm sorry, you're faded out there, ma'am.
Healthy.
Oh, Dr. Lee Norman, Secretary, KDAG, sorry.
Yes. Does your authority in 65 give you the capability to quarantine healthy people?
Yes, it does. We've never done that. It would be if they were a close contact of an ill person with COVID-19. So the authority, I do have that authority to do that if they're a close contact and therefore putting others at risk, yes. I've not had to do that.
Thank you.
During the entirety of
Madam
this.
Chair.
Thank you. Committee, other questions for our opponent conferees? Seeing none, then we'll thank you, Dr. Norman. Thank you, Mr. Lawrence, for your appearance and your testimony today. Appreciate your time coming over for that. Committee, then, that brings us to the close of the hearing on Senate Bill 273. We will close the hearing, and then we will turn to working Senate Bill 273. I understand that there are quite a few amendments from our committee members who have been working hard and diligently with our reviser staff, so appreciate all the hard work on the bill that has been put forward in it. And I believe it's best to work the amendments in the following order. We will follow the order like we do for the confirmation hearings and use the alphabetical last name from the senators. So unless there's general discussion, I guess we'll first entertain some general discussion and then we'll move into the amendments if there's any general discussion from the committee. Yes, Senator Thompson.
Just a quick question. I know I've got a number of amendments still being drafted by Mr. Thompson or his staff there at the revisers. So I'm kind of at the mercy of how swamped they are. And so I guess we'll see when we get around to T's. Gives me a little more time. But would like to, obviously discuss those amendments.
Thank you. And committee, to let you know, we are scheduled to work till 1 o'clock today. Appreciate everyone working through the lunch hour. And then the plan is to, after session today, since we're pro forma, and hopefully that will be shorter, we can come back this afternoon. We do have 1:30 committees that are still meeting today that have their work to finish also regarding bills they're trying to kick out of committee as well. So I don't want to interfere with the 1:30 committees, and then 2:30 will be in session. I would suggest, and this is the plan, we will reconvene as a committee to continue working Senate Bill 273 30 minutes after we gavel out of session today. And hopefully that won't be too late. I hate to set a specific time because I never know how long floor action will be, but so if we'll plan for 30 minutes to be back here after we adjourn on the Senate floor. So with that then, or is there any general discussion before we start working amendments? Yes, Senator Haley.
Thank you, Madam Chair. We have a caucus scheduled, Senator Corson and myself, at 3 o'clock, I believe, today. It should be very brief. I don't know where that is in a 30-minute consideration, but and it may not be material at that time. They may change it, but currently it is scheduled just for your and the committee's information.
Thank you for that information. Let's go ahead then, and we will set to reconvene at 3:30, but please listen on the Senate floor for an announcement regarding when we will be back hearing this afternoon. I'll make an announcement on the Senate floor about that. With that, then, a further discussion before we start working amendments. Seeing none, then, we have first, are there any amendments from Senator Baumgardner?
Yes, Madam Chair, and I still have amendments that we're working on, so we can start on one. I don't know that this is the best approach, that we do it alphabetical order, but we can certainly...
Well, let me suggest then, let's stand at ease for a few moments and contemplate what we have ready to go, what we don't have ready to go, and so we can do this efficiently and effectively to work the bill. So we will then stand at ease, committee. Thank you. Thank you for standing at ease for a few minutes. During the break, I did receive a phone call from our reviser, Mr. Thompson, kind of an update on where we are on those additional amendments that he's working on drafting. So there are a few outstanding still to be written and drafted. I believe after our 1:30 break, he will have an opportunity with other revisers to get those finished up. What I'd like to do with the time that we have, yes, Senator Baumgardner, did you have a question or comment? Or I think what we're going to do is, do we have small amendments, I would say, that are ready to go? Or, you know, kind of what's the will of the committee to get through these amendments as quickly as possible? What I would like to do is, if we have small amendments that we can start with and then get to the more comprehensive ones later, and sometimes if you're senator at the beginning of the alphabet, maybe your amendments aren't ready, and of course we'll circle back and we'll get these all done. So with that, then, Senator Baumgardner, you were about ready to go. Do you have a smaller amendment we can work?
Mine is not the smallest, and Madam Chair, I appreciate that let's start with that low-hanging fruit. So I am certainly in support of that. I do have the one. It's kind of it's a larger balloon filled with helium. But let's start with the low-hanging fruit, and if we get to mine, it's ready to go also. Thank you, Madam Chair.
Great, thank you. So Senator Wilborn.
Thank you, Madam Chair, and thank you, Senator from Miami, for helping us move along. First one I think I'll pass out. It is the one that was requested by the law enforcement agencies.
If you could make sure you speak clearly into your microphone so those following online can listen as well.
Thank you, Madam Chairman. Senator Rick Wilburn, Senate District 35. I have an amendment as it relates to the request by the law enforcement agencies, Kansas Chief of Police, Sheriff Association, and the Peace Officers Association, and we'll pass these out.
Would you like to explain your amendment or have the reviser explain your amendment?
I'll be glad to explain the amendment. Mr. Klump's testimony should be fresh in our mind, and it is on page 19, and it starts off providing the, just a minute here, along with the order. Changing, the main impetus here is installing misdemeanors back for civil disorder as opposed to a civil violation, and the rest of it is phraseology that adjusts to that change. His testimony, I think, was fairly explicit, and if there are any questions, I can ask him to come forward.
Thank you, Senator. Committee, any questions for the reviser regarding the amendment from Senator Wilborn? Seeing none, then, any discussion on the amendment from Senator Wilborn? Seeing, yes, Senator Corson?
I was just going to say, I will be supporting this amendment because of the reasons that Mr. Klump stated. I found to be persuasive, so I will be supporting this for those reasons.
Thank you. Senator Wilborn, did you have a motion?
I'll move my amendment.
Is there a second? Senator Corson? Thank you. Any discussion on the motion committee? Seeing none, we will vote on whether to amend Senate Bill number 273 with the motion offered by Senator Wilborn. All those in favor, aye.
Aye.
Opposed, nay. The ayes have it. The motion carries.
Thank you, Madam Chair. My next amendment we will distribute here, and I'll allow a moment to this change affects on page 8, and candidly, this language was supposed to be in the original draft, and we didn't get it into the original draft, and it is you might say, a cleanup or technical change. If you'll look at lines 41, upon receipt of request for a hearing under this section, the district court shall strike the word conduct and include the word schedule. A hearing within a hearing and give notice of such hearing to the aggrieved party within 72 hours after receipt of the request. Next line, the district court strike may and add shall not extend the time for a hearing, and then strikes lines 1 through 5 under any circumstances. It's just that simple. Tightening up and also offering more clarity.
Thank you. Any discussion on the proposed amendment? Seeing none, Senator Wilborn, do you have a motion?
I do. Thank you, Madam Chairman. I move the amendment.
Thank you. Second by Senator Thompson. Committee, you've heard the motion. All those in favor, aye. All those opposed, nay. The ayes have it. The motion carries. Since we are on section 4 of the bill, I have a short amendment along those lines as well, a little bit of what I thought was clarification for bringing an action in district court, that we clean it up and clarify that if you're going to bring your action in district court, that it be made under Chapter 60 of the Kansas statutes annotated. Chapter 60 is where we find the other action later in the section, and to clarify, it's a Chapter 60 action. I believe everyone has the amendment, and do we have any questions for the reviser on the amendment? Seeing none, then any discussion on the amendment? Yes, Senator Gossage.
I was just going to say it makes sense.
Thank you. Thank you, Senator. Other discussion? Seeing none, then I will move that we amend Senate Bill 273 with the amendment I passed out. Do I have a second? Senator Baumgartner.
Madam Chair, I second the motion.
Thank you, Senator. You all have heard the motion. All those in favor, aye. All those opposed, nay. The motion carries. The bill is so amended. Senator Gossage, I think you had an amendment.
I do, and even though it's several pages, it's actually short. And that is, in our previous discussions, we talked about how many of our constituents were concerned about too much authority given to a health director in a county or a city, and that we make it clear that they are to give advice, guidance, recommendations, but not to issue orders. That should come directly from the school board, the city council, the county commissioners board, et cetera. So pretty much wherever it refers to the health officer, a city health officer, a county health officer, starting on page 7, it is changed to recommendation, making it clear that orders would be coming from those other governing bodies. And then, so that's pretty much what you see as you go forward. On page 23, this was not in my original balloon, but I'm told by the reviser that because we are clarifying what can or cannot be done by the officers and to be consistent, this balloon appears elsewhere in this bill regarding other health officers, so, or from local bodies. So just wanted to put that same wording in there for the county officers. And then the rest just says recommendation.
Thank you, Senator. Committee, do we have any questions for the reviser regarding this amendment? It is several pages, and just want to make sure we don't have any questions for the reviser. I do have a quick question myself. On page 8 of the bill, in the amendment, we're striking through at lines 5 and 19 and 24 and things. City health officer and local health officer, is that the intent there to?
It is. If you'll see, it says, upon request by a person agreed by an order issued, well, since they can't issue orders, you would just strike that. Order issued by the governing body of a city, or the order issued by the county commissioners.
Thank you for clearing that up. Any other questions for the carrier of the amendment or the reviser? Seeing none, then, do we have a motion?
Move my amendment.
Do we have a second? Senator Thompson, thank you. Committee, you've heard the motion. All in favor, aye.
Aye.
Opposed, nay. The motion carries. Senator Thompson.
Yeah, I have one that's real low-hanging fruit, but it hasn't been prepared by Jason yet. I don't know if we can do it as a conceptual amendment, or do we need to wait on Jason and his crew at the revisers?
Let's make a request. We have other written amendments ready to be worked in the committee currently.
Okay.
Yes, Senator Baumgardner.
Madam Chair, I guess we will get to my amendment, my large balloon. And we have a copy of it to pass out.
Do you want to explain your amendment, or shall we have the reviser?
We will let the reviser work on revising, and I will explain.
Thank you.
One of the things that I know that we have discussed and had some concerns about has to do with the federal funding that comes into a state when we have a declaration of a disaster. And so what this does is, upon making such findings, the governor shall terminate state of public disaster. And it requires that the research department and a division of post audit and the division of legislative administrative services will provide assistance in getting information for the joint committee. So what it does is it gets that director of budget also involved and the division of post audit, so that we know funds that are coming our way. And the largest balloon on page 11, it is simply, it's providing that oversight and accountability with regard to federal funds coming into the state. And so it, before expenditures are made, before obligations are made from federal grants or other federal receipts due to the disaster emergency declared, that it will go through a process, and they're going to be approved by a majority of the members of that joint committee on emergency management. And they are authorized, it authorizes that committee to approve the requests, and also for them to authorize how those monies are expended.
Thank you. Any discussion or questions for the carrier of the amendment? Seeing none, then, would you like to move your amendment?
Thank you, Madam Chair. I'm happy to move my amendment.
Second, Senator Gossage. Committee, you've heard the motion. All those in favor, aye.
Aye.
Opposed, nay. The motion carries. Do we have another amendment ready to work currently? Senator Corson.
Thank you, Madam Chair. This is something that I just wanted us to consider as I was reading through this, and this would just simply say that it would clarify expressly that the joint committee may be conducted by electronic audiovisual communication if the chairperson determines that that is necessary. So I wanted to put before the committee to see whether they would like to expressly state that. I think one could argue that that may be implied. I know that such meetings have previously been conducted via WebEx and Zoom, so one could argue that this is not necessary, and I would definitely respect the wishes of the committee, but I wanted us to at least just think about if we wanted to expressly make clear that at the chair's discretion, that was an accepted way of meeting, because one could envision situations where physically gathering, either because of time being of the essence or weather or other conditions, would make that unduly burdensome. So I will respect the wishes of the committee as to whether they would like that to be expressly stated rather than maybe just implied, because it is not disallowed. Thank you, Madam Chair.
Thank you. Senator Wilborn.
Thank you, Madam Chairman. This should concern you, but this seems like makes sense. So particularly with the discretion of the chairman. So thank you.
I have a question for the reviser. If the committee meets by Zoom or WebEx, do they have the proper authority to conduct their business and any business that comes out of it? I don't recall whether the State Finance Council meets virtually. I think they do, and the LCC does as well. So I wouldn't see if the LCC and the State Finance Council meet virtually why the Joint Committee couldn't, but just want to make sure we're not running into any constitutional issues. If the reviser can answer that question just briefly.
Yes, thank you, Madam Chair. This is Jason Thompson with the Revisor's Office. My understanding is that it's being done with other interim committees, and so we feel like it's okay. I will, I guess that's probably it. And if I could, while I have the microphone open here, if you could pause whenever you introduce an amendment and identify the little name so that I can get it to Iris and get it up on the screen for everyone, that would help. I've been trying to rush it, but a little pause would be really helpful. Thank you.
Apologize, and certainly we can pause and do that. Any further discussion on the amendment or for the carrier of the amendment? Seeing none, then Senator Corson, do you have a motion?
Yes, Madam Chair, I would move my amendment.
Do we have a second? Senator Baumgardner. Committee, you've heard the motion. All those in favor, aye. All those opposed, nay. The motion carries. Do we have another amendment ready to be worked? Senator Corson.
I have one ready, Madam Chair. It's not lengthy, but it is a little bit of a policy choice. I mean, I think I will leave it to your discretion as to whether you would like to do this now. Thank you.
Thank you. If it's kind of a more in-depth policy issue, I believe we have about 15 minutes left. We can get started on it and see how far we get, I would suggest.
Thank you, Madam Chair. I will ask Darren to help me distribute.
And what's the number, please, so we can have the reviser pull it up? It should be on the first page. It should have a description, meetings, or in the box up there in the upper right corner, federal funds.
It says proposed amendments to Senate Bill number 273, executive orders.
There we go. Thank you.
And I would, just to make sure it's described completely accurately, if maybe I would defer to Mr. Thompson, and then I could maybe explain the reasoning if that would be helpful, but maybe if Mr. Thompson could briefly describe it.
Mr. Thompson, if you're available, please.
Thank you, Madam Chair. This is Jason Thompson with the reviser. Thank you for the procedure there. That worked really well. The balloon should be on the screen and you all should have it. The change is beginning on page 3. So this is in section 1, where the governor may issue her executive orders under section 1 and the powers conferred by this section. And rather than prior to issuing the order, sending it to the Attorney General, this would state within 24 hours after issuing the executive order, the governor would submit the executive order to the Attorney General. So it would be active and in effect when it was submitted rather than proposed. So that's the change on page 3. The change on page 4 follows that line so that the Attorney General issues their opinion within 24 hours of receipt of the order. And then within 48 hours after issuing an order under this section, the governor also submits to the Joint Committee on Emergency Management. And rather than being proposed and potentially to be approved by the committee, it can just be null and void if it fails to receive an affirmative vote of the committee. So the committee still reviews the order and can nullify it, but they no longer have to approve the issuance of it because it's already been issued. And that's it.
Thank you. Committee questions for the reviser? Seeing none, then questions or comment or discussion on the amendment, including questions for the carrier of the bill. Yes, Senator Baumgardner.
Thank you, Madam Chair. I don't have a question on this. I have a concern about this, and we've seen it play out. It's my understanding that when we had the executive order with regard to churches and religious organizations meeting over the Easter holiday, that was passed by the Attorney General, and it was urged that it not move forward. And the Attorney General wasn't asked to make a ruling, wasn't asked, what is the language here particularly? Was not asked to provide a public opinion, but did offer an opinion. It was ignored, it moved forward, which put the state in litigation. So I would oppose this because I think that the way it is within the bill right now, it provides that appropriate balance of check and balance. And I just can't support it because we've seen where I think perhaps there's been, I will simply say, misdirection on a few executive orders. Thank you, Madam Chair.
Thank you. Committee, other discussion, questions? Seeing none, would you like to, do we have a motion?
Yeah, can I just briefly give a little bit of my rationale for offering the amendment, just very briefly?
Sure, Senator Corson.
Thank you, Madam Chair. It was just to think about situations where just every hour, every minute could be of the essence when it comes to potentially saving lives and properly responding. And this would still, I believe, very much provide appropriate oversight from both the Attorney General and from the Joint Committee on Emergency Management. It would just avoid a situation where the governor were not able to issue an executive order while we were awaiting Attorney General review and while we were awaiting on a decision from the Joint Committee. And so this would just allow that order to go into effect. And if the Joint Committee felt like it was not something that they wanted to support, then it would be pulled back and would be null and void. And so there would still very much be opportunities for review and input, but you know, without trying to think of every hypothetical, one could envision certain scenarios where, as I mentioned, literally every hour could be of the essence in trying to respond. And I would not want to see a governor unable to respond for a 24 or 48-hour period. So that was the rationale. With that, I would move the amendment.
Thank you. Do we have a second? Senator Haley. Discussion on the motion. Seeing none, then, you all have heard the motion. All those in favor, aye. All those opposed, no.
No.
Okay, the motion fails. We're back on the bill. Do we have other amendments at this time ready to work? Seeing none, then. Committee, I believe if we adjourn a little prior to our 1 o'clock extension, that will give the revisers just that much more time to work on getting amendments ready for when we reconvene. Committee, I'll make an announcement on the Senate floor today while we're in session about reconvening. Again, I would hope to allow enough time for a brief caucus that we heard is going to be held at 3 o'clock today. And then we are likely going to try to be reserving room 112. So this particular room isn't available. Is that 112 North? 112 South, I think it is. North, okay, 112 North. Not for certain yet, but again, listen for the announcements on the Senate floor. Thank you, committee, for your work today and for the robust debate and discussion. And for those of us joining online, thank you. We are recessed.